This session will cover various compliance regulations and laws that recipients of federal funds must comply with. When we submit a proposal to the federal government or accept an award, we have to agree to various assurances, representations, and certifications. An assurance is a written guarantee or pledge that one will act in a certain way or comply with the terms and conditions of an award. A representation is an account or statement of fact concerning an offeror and its capabilities and its abilities to perform. It can be viewed legally as an inducement to parties to enter into a contract. A certification is a submission of documents that serves as a guarantee the award applicant meets certain standards or will comply with certain governmental acts. False certification may make the individual subject to criminal sanctions. A warranty is a promise that the goods or services described within the terms of the contract will be delivered as represented or promised. The Drug-Free Workplace Act of 1988. The regulations are applicable to all federal grants to individuals and organizations, regardless of the award size. Some of the requirements are publishing a statement notifying employees that lawful use of a controlled substance is prohibited in the workplace, establishing a drug-free awareness program to inform employees about the dangers of drug abuse in the workplace, notifying the employees that as a condition of employment on a grant or contract, the employee agrees to abide by the terms of the institutional policy and notify the employer of any criminal drug statute conviction occurring in the workplace no later than 5 days after such conviction. Notifying his federal sponsor within 10 days after receiving such notification. Imposing sanctions or requiring participation in rehab program. And making a good faith effort to continue to maintain a drug-free workplace. The Drug-Free Schools and Communities Act requires schools, colleges, and universities to implement and enforce a strict drug prevention program and policies as a condition of eligibility to receive federal financial assistance. Institutions must adopt and implement a drug prevention program to prevent the unlawful possession, use, or distribution of illicit drugs and alcohol by students and employees on an institutional premises. Also requires an annual distribution in writing to each employee and student. Drug-Free Workforce DFAR Clause 252.223.7004. Note, this is workforce and is different from the workplace previously discussed. The contracting officer will use this clause in contracts involving access to classified information or any other contract when the contracting officer determines that the inclusion of the clause is necessary for reasons of national security. One of the requirements of this clause is that the contractor shall establish a program that provides for testing for the use of illegal drugs by employees in sensitive positions that are working on the contract. Lobbying. No appropriated funds may be expended to pay a person to lobby the federal government for purposes of influencing or attempting to influence federal officials in connection with a federal action such as the awarding of a federal contract. The Lobbying Disclosure Act of 1995. This requires an institution to disclose if it has hired lobbyists or lobbying firms to engage in direct lobbying activities of the federal government, sometimes referred to as the LDA or Simpson-Craig Amendment. The Hatch Act. This legislation was enacted to limit the political activities of employees whose principal employment activities are funded in whole or in part with federal funds. This is not applicable to institutes of higher education or employees of such institutions even when they're paid from federal funds. Occupational Safety and Health Act, otherwise known as OSHA, makes sure employers provide their workers a place of employment free from recognized hazards to safety and health. The Act specifically requires employers to furnish each employee a workplace that is free from recognized hazards that could cause death or serious physical harm, and to comply with the standards promulgated under the Act. Among the requirements of the Act are labels or other appropriate warnings so that employees are aware of hazards, emergency treatment, proper conditions, and precautions of the safe use or exposure, including provision for protective clothing and equipment. Material data sheets are an example of compliance with this requirement. The Davis-Bacon Act. This applies to construction projects funded by the federal government. It requires contractors to pay wages to laborers and mechanics at a rate no less than a minimum wage specified in a wage determination made by the Secretary of Labor. The Walsh-Healy Public Contracts Act is applicable to contracts furnishing supplies and equipment over $15,000. The Act stipulates a contractor comply with the government's minimum wage, also has requirements for child and convict labor restrictions, and work safety provisions. Also requires overtime pay of at least 1.5 times a worker's regular rate of pay for all hours worked in excess of 40 hours. The Fair Labor Standard Act was enacted to establish a minimum hourly wage, overtime pay, and regulate child labor. Overtime pay is required for non-exempt workers. Overtime pay is not required for exempt workers as defined by the Department of Labor. The Copeland Anti-Kickback Act. This law makes it unlawful to induce by force, intimidation, threat of procuring dismissal from employment, or otherwise any person employed in the construction or repair of public buildings or public works financed in whole or in part by the United States, to give up any of the compensation to which that person is entitled under a contract of employment. Combating trafficking in persons. This is applicable to all federal grants, contracts, and cooperative agreements. Allows the awarding agency to terminate the agreement if awardee or any subawardees is engaged in human trafficking or forced labor. Contractor Code of Business Ethics and Conduct. This is applicable to all contracts expected to exceed $5 million and the performance period is 120 days or more. The awardee must have a written code of conduct in place. Appropriate training is provided to employees and internal controls exist. The CREATE Act, Cooperative Research and Technology Enhancement Act of 2004. The purpose was to promote cooperative research among universities, the public sector, and private companies by treating joint inventions as if they had a single owner, but only if the collaborators had a written agreement before the invention was created. Civil Rights Act of 1964. Programs or activities receiving federal financial assistance must comply with the Civil Rights Act of 1964, prohibiting discrimination on the basis of race, sex, color, or national origin. Sexual harassment. Many federal sponsors have enacted sexual harassment provisions that are flowed down to the grantees. Grantees are required to have education and training for their employees, supervisors, and workers to understand what sexual harassment is and how to prevent it. There needs to be a reporting and investigation procedures in place. Many federal agencies require the grantee to notify the sponsor if anyone working on the grant has been sexually harassed. The Health Insurance Portability An Accountability Act, known as HIPAA, required the creation of national standards to protect sensitive patient health information from being disclosed without the patient's consent or knowledge. It limits the use of identifiable health information identified as protected health information, known as PHI. For research, this has meant additional language in human subject consent forms and increased scrutiny from the IRB. The Federal Funding Accountability and Transparency Act, known as FFATA, is an openness in government initiative. Recipients of awards are required to report subawards made in excess of $30,000 on the FFATA reporting system. Vendor payments exceeding $30,000 are also required to be reported. Information is accessible on usaspending.gov. System for Award Management, known as SAM. It's the entity registration for entities that want to apply for federal funding. It has an area for online certifications, so that once these certifications are completed, they do not have to be submitted with every proposal. Certifications are updated on an annual basis. It contains the excluded parties list, where it lists parties that are either debarred or suspended. It has wage determinations. If your contract is subject to the Service Contract Act, you want to look at this area to make sure that you're paying the minimum wages for those particular jobs in those geographic locations. These wage determinations are set by the Department of Labor. SAM also lists contract opportunities. Formerly was known as Fed Biz Ops. When the government is wanting to procure something, they have to announce it on contract opportunities. This is similar to federal financial assistance that is announced on grants.gov. They have the listing of assistance listing, which was formerly known as a Catalog of Federal Domestic Assistance. FOIA is a U.S. law that grants the public the right to request access to records from federal government agencies, and its purpose is to promote government transparency. But requests can be denied if the records fall under one of the 9 exemptions. The list of exemptions: classified national defense and foreign relations information, internal agency rules and practices, information that is prohibited from disclosure by another law, trade secrets, and other confidential business information, intra-agency or intra-agency communications protected by legal privileges, information involving matters of personal privacy, certain information compiled for law enforcement purposes, information related to the supervision of financial institution, and geological information on whales. Information the government typically releases. Proposal information after the award has been made. Notice of grant awards or information included in those notices. Interim and final progress reports. Financial reports. Final reports of audits, surveys, or evaluation of awardee performance. FOIA access is usually denied to the following: pending or disapproved applications, financial information pertaining to specific individuals, information subject to the Privacy Act of 1974, confidential information, opinions expressed in interagency correspondence, and information that, if released, would adversely affect patent or other valuable commercial rights. Data access, known as the Shelby Amendment. It's applicable to source data produced with federal funds and cited publicly and officially by a federal agency in support of an action that has the force and effect of law, including regulations and administrative orders. Research data is defined as a factual, material, commonly accepted in the scientific community as necessary to validate research findings. When you submit a research proposal, you agree to comply with many of the federal environmental protection rules and regulations. These are listed on this slide. The Federal Information Security Management Act, known as FISMA, the National Institutes of Standard and Technology, known as NIST, is charged with implementing FISMA at the federal level. It's a basic safeguarding of contractor information systems that process, store, or transmit federal contract information. There are a number of standards that the awardee must meet to keep its computer system secure. Dual-use research of concern is life sciences research that, based on current understanding, can be reasonably anticipated to provide knowledge, information, products, or technologies that could be directly misapplied to pose a significant threat with broad potential consequences to public health and safety. If you're submitting a proposal to NIH that may have dual-use research of concern, you have to include a risk mitigation plan. For NSF, you must check the associated box on the cover sheet. Misconduct in science. The uniform definition of research misconduct, which all agencies were required to adopt, is fabrication, falsification, or plagiarism in proposing, performing, or reviewing research or reporting research results. Fabrication is making up data or results. Falsification is manipulating research materials, equipment, or processes, or changing or omitting data or results such that the research is not accurately represented in the research record. Plagiarism is the appropriation of another person's ideas, processes, results, or words without giving appropriate credit. There are multiple phases that occur in response to an allegation of misconduct in science. First, there's the inquiry phase to determine whether there is merit in the allegation. If so, an investigation is initiated. Investigation. It's a formal examination of the facts to determine whether there was actual misconduct. Adjudication, where misconduct is found, recommendations and corrective actions are determined. Note, at different points in this process, the Research Institute is required to notify the funding agency of the status of the process. Debarment and suspension. This is generally when applicants are barred for participating and receiving awards from the federal government. Suspension is typically a temporary measure. There's a 12-month limit. It's usually used pending the completion of an investigation or legal proceeding. Debarment is usually 3 years in length, based on a preponderance of the evidence, usually a conviction. False Claims Act. The false claim action contains 4 material elements: the provider made, used, or caused to be made, or used a record or statement to get a claim against the United States paid or approved. The claim was false or fraudulent. The provider knew the claim was false or fraudulent. The government suffered damages as a result of reliance on the claim. Civil penalties. Violators must repay 3 times the amount of the damages, plus a mandatory civil penalty. Under qui tam actions, individual citizens who know that other individuals or companies are defrauding the government may sue on the government's behalf and share the proceeds of the suit. These individuals are sometimes called whistleblowers. Under the Whistleblower Protection Act, it prohibits reprisals against employees for disclosing gross mismanagement of federal contract or grant, a gross waste of federal funds, an abuse of authority, danger to health or safety, or a violation of a law, rule, or regulation. The Fly American Act. All air travel and cargo transportation services funded by the federal government are required to use a U.S. flag air carrier service. Note, tickets, cost, and convenience are not exceptions to the Fly America Act. There are some exceptions to the Fly America Act. When a U.S. air carrier is not available, when using a U.S. carrier service would extend the travel time by 24 hours or more, when a U.S. carrier does not offer a nonstop or direct flight between the origin and destination, and using a U.S. carrier increases the number of aircraft changes outside the United States by 2 or more, extends travel time by 6 hours or more, or requires a connecting time of 4 hours or more at an overseas interchange point. When the flight time from origin to destination is less than 3 hours and using a U.S. flag carrier doubles the flight time, or when there is an applicable open skies agreement in effect that meets the requirements of the Fly America Act. Currently, the U.S. has open skies agreement with the European Union, Australia, Switzerland, and Japan. These exceptions provided by the Open Skies Agreement do not apply if your transportation is funded by the Department of Defense. Debt delinquency, OMB Circular A 129, requires federal agencies to take appropriate steps to ensure those receiving federal financial assistance are not delinquent on loans or other accounts to the federal government. In the case of awards to institution, the institution must certify it is not delinquent on federal debts. No awards will be made to delinquent institutions or individuals. Federal agencies may collect delinquent debt by offsetting payments due under other federal programs. Military recruiting on campuses, known as the Solomon Amendment. No federal funds if the institution has a policy that effectively bars military recruiting on campus, military access to student directory information, or bars operation of a senior ROTC unit on campus. Acknowledgement of federal grant support, known as the Stevens Amendment. When issuing statements, press releases, requests for proposals, bid solicitations, or other documents describing projects or programs funded in whole or in part with federal money, all grantees receiving federal funds, including but not limited to state and local governments, shall clearly state the percentage of the total cost of the program or project which will be financed with federal money, the dollar amount of federal funds for the project or program, and the percentage in dollar amount of the total cost of the program or project that will be financed by non-governmental sources. Educational institutions receiving federal funding are required to hold an educational program pertaining to the United States Constitution on September the 17th of each year. FAPIS, the Federal Awardee Performance and Integrity Information System. It's a government-wide database meant to compile integrity and performance information on federal grant and contract recipients in excess of 500K. FAPIS's goal is to provide information to government officials for evaluating business ethics and past performance of prospective awardees, and to protect the government from making awards to non-responsible entities. The Family Education Rights and Privacy Act, known as FERPA, or also known as the Buckley Amendment, protects the privacy of students' education record. Institutions must have a policy to prohibit disclosure of a student's protected information to a third party. A student can opt out of having directory information, name, address, and phone number disclosed. The Crime Awareness and Campus Security Act, also known as the CPRA Act, applies to all U.S. institutions of higher education participating in federal student aid programs. Institutions must publish and distribute annual campus security report to current and prospective students. There's also a requirement for timely warning notices, emergency notification, and emergency response. Employment eligibility verification, known as E-Verify, is a web-based system that allows enrolled employers to confirm the eligibility of their employees to work in the United States. Requires contractors to use E-Verify to verify the employment eligibility of employees. Institutions of higher education can choose to verify only those employees directly working on the contract that included the clause